Good morning, Judge Shapiro. I just wanted to let you know that it looks like we have representatives for both sides as well as the court reporter, and I can bring them in whenever you're ready.
Lori?
Yep.
Yeah, I just need a couple more minutes. I'll come on when I'm ready.
Okay, sounds good.
Thank you. Morgan, I'm ready to go.
Okay, I'll bring them right in.
Thank you. Right. Good morning, Ms. Watson and Mr. Cousins.
Good morning,
Your Honor.
Everyone hears me, it seems.
Yes, sir.
All right. Ms. Roberts, are you ready or you need a minute still?
All right, ready. I'm ready, Judge.
You're ready. All right. I'm going to call the case. I'm sorry, sir. Did someone say something? No. Okay. This is Court of Claims case 22-159, Amy McCormick and Robert McCormick versus Michigan State University. This is the defendant's motion for summary disposition. Before the defense proceeds, I have a question. Am I correct that this case is only about the NOI and not a statute of limitations issue?
I would defer that question, Your Honor, to Ms. Watsa. My understanding is that the motion asserts that the NOI is untimely and that therefore the complaint is untimely.
Okay.
Your Honor,
Yeah, it's her motion, right?
pardon me. Yes. I would say, I think it's intertwined. Neither the notice of intent or the complaint were filed timely, pursuant to the Court of Claims Act.
And the reason that the complaint was not filed timely derives from the failure of the NOI or something else, because isn't it a 6-year statute?
So it would be the notice provision in the Court of Claims Act, Your Honor. Yes. So I'm sorry, I think I misunderstood your question. So MCL 600.6431 states that the claimant must file a notice of a complaint or a complaint within here would be the 1-year time frame, starting from accrual, which was December 31st, 2019. So that's what's at issue here, Your Honor.
Okay. I think I understand your position. I have a couple of questions, but you can lay it out for me first if you'd like.
Sure. And I think, to expedite this, obviously, as you know, this has been fully briefed. We filed our motion in brief, and I know Mr. Cousins filed a brief for plaintiffs, and we filed obviously our reply brief. So I don't want to belabor any points that I think are pretty well established from the briefing. I will say, I think we can kind of skip over the Court of Claims Act part, because I don't think Mr. Cousins will be arguing. It appears from the brief. I think we all agree that if we're looking at just MCL 600.6431, this case is untimely. It appears plaintiff's claims are essentially that MCL 600.5855 tolls the statute of limitations here for the Court of Claims Act, if we want to call it a statute of limitations. And that is the only reason that it's not untimely. Obviously, plaintiff's counsel is free to disagree with me if I'm misrepresenting his arguments. But here, fraudulent concealment under MCL 600.5855 doesn't save plaintiffs here. This case is untimely, period. The only way that it could be saved is pursuant to this fraudulent concealment statute. And even if it's applicable, which I think is doubtful, because I have not seen any cases that apply this statute in a factually similar way here to this case. Even if it does apply, plaintiffs didn't plead active fraudulent concealment, but rather mere silence. And the case law indicated in our briefing, both in our initial brief and then our reply brief, lay that out as a requirement. Again, plaintiffs allege mere silence, which is not sufficient. So MCL 600.5855 isn't even applicable here. Further, even if it was, as argued in our briefing, the exhibits establish, and even the complaint establishes, that plaintiffs were aware of a possible cause of action here by at least December 2021, or pardon me, December 2019, against the possible defendants here, Michigan State University. And so that 2-year time frame from MCL 600.5855, sorry.
You're saying 12, the date of termination, is that what you're referring to?
Yes, yeah, I mean, so the parties were aware of what was going on here. The parties were aware of the integration. They were aware that she was terminated. So it's not a question of, you know, when people were aware of what, essentially, in terms of the accrual. Plaintiffs are alleging that Michigan State University didn't tell them, plaintiffs specifically, that it had incorporated or taken on the liabilities of the College of Law. And there's just no case law to support that's, you know, complies with fraudulent concealment or constitutes fraudulent concealment, I should say.
I do have a question.
Sure.
MSU purchased, if I have it right, all the debts and obligations of the COL parties.
Yes, the remaining, I believe the wording is the remaining assets and liabilities, I believe, were all purchased by a Michigan State.
This is essentially a successor liability case.
Yes, Your Honor.
I didn't hear what the judge said, please.
I said, so this is essentially a successor liability case.
Yes, yep, and we make that argument. We've made that argument multiple times now in the Court of Claims originally when it was removed, when the case that was filed in Ingham County was removed and then sent back. And now,
if you have succeeded to their rights and liabilities, why does the state get the benefit of the Court of Claims protections that would never have been afforded to a private corporation whose obligations and liabilities they've purchased?
Your Honor, this case is still protected under governmental immunity under the Court of Claims Act. There's no case law that indicates otherwise.
Well, that was going to be my question. Is there any case ever dealing with the state as a successor liability setting?
Not that I've seen, Your Honor. I didn't come across any in my research. I'm not saying that necessarily there's none in existence, but I have not seen any. And so I have not seen any breach of immunity here. So it's defendant's argument that this claim is barred by the Court of Claims Act, period. There's no saving here with the Court of Claims Act.
I got another question for you, if you
Sure.
don't mind me. I'm kind of used to that from the Court of Appeals, I guess, I don't know. So for the brief, I was looking for something that indicated some type of public release or availability of the document that would give notice that MSU purchased everything. And the only thing that was mentioned in your brief was that a FOIA request could have been made. Was there any public release, anything else that I could rely on your side as to whether or not this information was somehow withheld? And I understand what the requirements are.
Sure. So I know that there was plenty of, plaintiffs were aware of this merger. I don't know that I don't know that the specific asset purchase agreement was published anywhere, but it's a publicly available document. It could have been attained after it was signed and finalized, could have been attained via a FOIA request. I do know, as argued, plaintiffs were aware of the integration. It was highly publicized that MSU.
I don't have any doubt about that. I mean, right. I have the letter.
I'm
Right.
sorry, Judge, you kind of cut her off, so I didn't hear what you said.
Sorry. I said, I understand that I have her letter, so I don't think that's a particularly significant, I mean, I think she was well aware of the merger, although Mr. Cousins may have something to say about it. In which case you're welcome to rebut.
Yes, and as we argued also in our initial motion and brief, that this high level of specificity of, plaintiffs were not aware of an asset purchase agreement, which, indicated that defendants took on the remaining liabilities of the College of Law. That hyper specificity is not supported by the case law, period. MCL 600.5855, the case law essentially just indicates that plaintiffs are held to a diligent investigation standard, and they're held to what they ought to know. And for those reasons, Your Honor, as also argued in our briefing, plaintiffs' claims are barred, and this case should be dismissed.
Okay. So, Mr. Cousins, will you don't have to start with this, but something I want to know is, do you have any evidence of affirmative concealment? If you could touch on that during your argument, because obviously that's their primary argument. If you've got something factual, that would be great. If not, I'm ready to hear the rest.
The court should deny the university's motion because Michigan State University is guilty of fraudulent concealment of its assumption of liability of the Detroit College of Law. And plaintiffs could not know and did not know that the university was the party responsible for the breach of contract by DCL. There's no dispute here that
I'm sorry to interrupt right away, but when we say DCL, we also mean MSUCOL, right?
Yes, that's correct. I've come to refer to it as DCL, and I suspect that's a little sloppy, but maybe everybody does. MCL 600.5855 was designed for a situation like this. Under the statute, a claim is timely if it is filed within 2 years of a party learning of the existence of a cause of action or learning of the identity of the party responsible for the cause of action, if those facts had been concealed when they should have been disclosed. Plaintiffs did not know that MSU was the party responsible for DCL's breach of their contract until the asset transfer agreement was filed in the circuit court as a defense in their action against DCL.
So the circuit court case, did that start out in the Court of Claims, or it was initially filed in the circuit court?
No, it was filed in the circuit court. The defendant removed it to this court. Judge Gleiser held that Detroit College of Law is not a public body, a decision that plainly correct, and sent it back to the Ingham Circuit Court, where the matter was litigated on motions.
And what was the named defendant in the circuit court case?
Circuit court case, it was the Michigan State University College of Law.
Okay.
Michigan State University as an entity was not a party to that litigation. Now, plaintiffs commenced this suit against Michigan State promptly on learning that it was the party responsible for the contract breach. MSU did. I'm sorry, Your Honor.
That's the easy part of the argument. The tougher part is the diligence.
Yes. The plaintiffs were extremely diligent. They knew of a cause of action, but the cause of action of which they were informed was a cause of action against the Detroit College of Law. They had no notice or knowledge of the existence of the asset transfer agreement. And this is a situation in which silence is the equivalent of an affirmative act. For whatever reason, I am looking at the handsome face of our court reporter and not Your Honor. I'm wondering if the monitor could switch it back.
It should be set to gallery view, so you should be able to see everybody.
Okay, I am now set to gallery view and everything is fine. Thank you so much. So What happened here is a pretty neat trick. And Your Honor touched on it in your question to Ms. Watson. MSU didn't tell anyone about the existence of the asset transfer agreement. The people who knew about it were those who had negotiated it and written it and implemented it. The asset transfer agreement wasn't a necessary precursor to the merger. Everyone knew about the merger of the law college with the university. That's not the issue. The issue is that MSU agreed to become a successor to the Detroit College of Law. That is not assumed. The law is pretty clear on that, that successorship is not presumed. It must be expressly agreed to. And that's what happened in this case. MSU told no one in the university community, except those who were responsible for administering this act, that it had become the successor to DCL. And plaintiffs had no idea that MSU was the responsible party. So what happened?
Were there negotiations going on during this time between the parties?
The plaintiffs have no actual knowledge of that. We assume that to be true.
No, I mean between your plaintiffs and either DCL or MSU. In other words, were there meetings in which one might anticipate that something like this would be revealed?
There was no interaction with the university. There was interaction with officers of the Detroit College of Law. Okay. And while it is a disputed question of fact, if Ms. McCormick were to testify, she would say that she was told by the chief officer of the Detroit College of Law that it was uncertain whether MSU would agree to recognize her contract and might repudiate.
That seems to be even in the August 19 letter. This goes before, which she says, I appreciate your concern. MSU might try to assert the position it will not respect, not honor this College of Law liability.
Correct. So what the plaintiffs did not know for certain, but they had reason to think that Michigan State University had no interest whatsoever in their contract with DCL. That's why they sued the Detroit College of Law. They sued DCL under the theory that there was a 6-year limitations period, and DCL had, in fact, repudiated the contract. The repudiation of the contract is not a disputed fact. It's very clear the contract was breached. The trial court, the Ingham Circuit Court, held that the asset transfer agreement was sufficient to make provision for creditors. Plaintiffs respectfully disagree with the ruling there, and that is pending before your colleagues in the Court of Appeals.
Oh, really? You have a case for that, right?
That's the other case. Yes, Your Honor.
I'm sorry, Judge, I can't hear you.
You're not hearing me? I'll just get closer. I apologize. My question was, I wondered, Mr. Cousins, if you happen to have that case number at hand. If not, don't search.
Regrettably, I do not. Your Honor, I'm recovering from cataract surgery and working from home, and I don't have my complete file.
No problem.
Now, the university's silence is the prototype of fraudulent concealment under the facts of this case. The university concealed a critical fact when equity required that it disclose that fact. So what happened here is a neat trick, and Your Honor touched on it earlier. An entity not possessed of statutory immunity transferred its liabilities to an entity with statutory immunity. And the successor entity now relies on its immunity to avoid the liability which it willingly accepted. Now, there are 4 points to be considered today. The first is that the university is guilty of silent fraud because it had a duty to disclose that it had assumed liabilities of DCL, and that silence under these facts can be an affirmative act. Second, plaintiff's complaint adequately notifies the university that it has engaged in fraudulent concealment of the fact that it is the successor of DCL. Third, plaintiff's claim is timely under the Court of Claims Act because they commenced their action within 2 years after they learned that MSU, not DCL, was the party responsible. And lastly, despite the university's argument, the university's contention here would leave the plaintiffs completely without any remedy, despite their acting with diligence. Let me first address the issue of fraud.
Well, let me stop you there. I mean, there's diligence and there's diligence, and the defense position is, if you want to make sure you sue the right party, then ask for the information.
Well,
either informally or in the FOIA request.
The issue of the FOIA request is interesting because to submit a FOIA request, you have to know or believe that a document exists. The document certainly was a public record and is subject to the Freedom of Information Act, but the plaintiffs had no reason to submit a request because they didn't know about the transfer of liabilities at all. And nothing.
Well, they certainly could have asked for all the relevant transfer documents, right? Or bill of sale or whatever, I mean, in a general request as opposed to, I know you got this.
If they had any reason to suspect that the university was somehow responsible here, then yes, they could have made a FOIA request for a variety of documents. But that presupposes something, that is that the plaintiffs had some idea that the university had taken on these responsibilities. And in fact, the reverse was true. They had reason to believe at the time that the university did not take on the liability for their contract.
And that's because of the statute or something else?
No, it's because of informal conversations between the plaintiffs and officers at DCL.
Has she been deposed?
She has not. No discovery has occurred in this case.
Well, are you going to allege that in fact she had conversations with DCL so I mean, I realize DCL is, I don't know what they succeeded to, whether DCL actions are relevant here, but are you going to present evidence that you believe that there were misleading affirmative statements made?
The Amy McCormick, if called to testify, would say, as mentioned in her letter, that she was given reason to believe that Michigan State University would not honor her contract, would not absorb liability for it. And therefore, she had to look to the Detroit College of Law as the responsible party for the breach. Now, the statute that we're talking about permits the court to find that silence can be an affirmative act. The statute says that a cause of action may be initiated within 2 years of learning of the existence of a cause of action. That's not the issue here, or of the identity of the party responsible. And that is the case here. And the premise of the statute is that a party can't benefit from sequestering critical facts. The statute incorporates the common law doctrine of silent fraud. The case law is very clear on that. Silence can be fraud.
Too bad you're not an insurance company. You'd win for sure.
Well, and in fact, that is what happened in Codra versus American Select Insurance Companies, where an insured knowingly and deliberately failed to disclose a critical fact. And in that opinion, unpublished, but nevertheless,
But I think wasn't it in response to a question?
I'm sorry, Your Honor.
It wasn't in that case the claimant's failure. I mean, sorry, the claimant's alleged false statement came in response to or failure to make a statement came in response to a question.
Yes.
I don't remember exactly, but here there's not a question from you.
No, that is true. And in Codra, there was a more or less deliberate and affirmative misrepresentation. But the comment by the court is what is critical, because in the decision, Among other things, the court says fraudulent concealment may occur if a person remains silent when fair dealing requires him or her to speak. And that is what we have here.
Does it use the term fair dealing?
I am quoting from the case. Fraudulent concealment may occur if a person remains silent when fair dealing requires him or her to speak. That
And
is,
this is CODRA?
that is CODRA at
Okay.
at slip op page 4.
Okay. You got
Now,
anything published?
It has not been published.
No, I'm saying, have you got any other cases you want to rely on that are published?
No, I do not, in part because CODRA is really marvelous guidance. The facts of the case are well different than the case here, but the comment by the court is exactly consistent with the purpose of the statute. The case law is replete with recognition that the fraudulent concealment statute adopts the common law doctrine of silent fraud. And under that doctrine, silence can be an affirmative act. Now, defendant says that the university didn't conceal plaintiff's possible claims. Well, okay, that's not the issue. Or the identity of potential defendants. Yes, they did. The university did not disclose to anyone that it had succeeded to the liabilities of the Detroit College of Law. MSU certainly sequestered the identity of the party responsible for the breach of contract by DCL. Plaintiffs knew about their cause of action. After all, they sued DCL, but they didn't know of the successor agreement. Now, plaintiff's contract was very well known to Michigan State. As the court has referenced, Ms. McCormick reminded the dean of the law school of her intention to enforce the agreement. It is impossible to believe that Michigan State was ignorant of plaintiff's contract. If they, Ms. Watts is a fine lawyer, but I don't think she was the one responsible for negotiating this asset transfer agreement. They had other people who must have, before they assumed liabilities, looked around to see just what liabilities they were going to assume. MSU knew that it was assuming a liability to plaintiffs. And if that is a disputed question of fact, so be it. But I am all but certain that they knew of this contract and knew that DCL intended to breach it. So the university can't hide behind a limitations period when it failed to notify plaintiffs that it had assumed liability for their contract. Silence in this case was fraudulent concealment, and that is the essence of the question before the court. Now, as regards pleading, plaintiff's complaint raises the issue of fraudulent concealment. At paragraph 31, the complaint says that the failure to disclose the existence of the assumption of liabilities was a knowing, deliberate, and willful fraud and silent fraud. Plaintiffs have pleaded fraudulent concealment. What the complaint doesn't say is that silence can be fraud, but they have pled silent fraud, and I think that that is adequate pleading. As regards the limitations period, my friend Ms. Watts makes an argument which is completely contradicted by the statute. The limitations period is 2 years from discovery. It doesn't extend the existing statute of limitations. The statute couldn't be more clear. If a party discovers the existence of a cause of action or discovers who the responsible party is, they have 2 years from the date of discovery to bring their cause of action. Finally, the university's argument here leaves plaintiffs without any remedy. University says that they're not without a remedy. They could have sued MSU under a successor liability, except they didn't know Michigan State was a responsible party. They're being told their claim is untimely. The trial court says you can't sue DCL. MSU says you can't sue us. It's as if parties are pointing fingers at each other and saying each of us is immune from liability. With respect, the result is unconscionable.
So, I'm sorry, Mr. Cousins, the Court of Appeals case, that is the question that was decided in circuit court that DCL had satisfied its obligations to protect its creditors. Am I right?
That is correct, Your Honor.
And what is the status of that? Has it been argued?
It has been fully briefed and we are awaiting an argument date. Knowing the court's schedule, I suspect that it will be June or July before we get a panel.
Okay.
Bottom line is the court should deny the university's motion and find that plaintiffs commenced their action promptly on learning that MSU had assumed liability. That is the legally correct outcome, and it is also the right outcome. I thank you, Your Honor, for your time and attention and excellent questions.
Thank you, Mr. Cousins. Ms. Watson, we're back to you.
I have just a couple quick points. I don't want to reiterate everything I already argued.
Okay.
I will note, so in our reply brief, we did note the Court of Appeals number. It's 362932. And that's at footnote 3 of our reply brief.
Great, thank you.
And so again, I won't argue anything about, the merits of the case or the Court of Appeals case. Just a couple quick points. That Codra case, Your Honor hit the nail on the head. That's a completely different situation. That's a situation where the defendant had a duty to the plaintiff to disclose certain information and failed to do so, I believe.
One would hope, and I'm just talking out of school here, that a multi-billion-dollar institution could manage to make the same requirements as Joe Blow, who doesn't know anything, filling out his insurance application. Having said that, I understand the distinction you're making, and it's quite evident.
Sure, Your Honor, and also I also will note, unless I've missed something, the Codra case does not deal with MCL 600.5855. Pardon?
I don't think it does.
Right. So it's not even applicable in this case then, and not to mention it's also unpublished. So the facts are distinguishable. The relationships between the parties are distinguishable. Doesn't deal with the at issue statute, let alone the Court of Claims Act. And it's just, defendants would argue that it's completely irrelevant here. Defendant, pardon me, did cite case law that is binding, that is on point, and does deal with the at issue statutes. And those cases indicate that there needs to be active or affirmative acts of fraud. And that's simply missing in this case. Plaintiffs have not argued or pled that there were any affirmative acts of fraud here. Further, Your Honor, what defendants knew is essentially irrelevant here, because as we've kind of circled around, MCL 500 or 600.5855 talks about not only, what plaintiffs knew, right, but should have discovered. And that's that diligent investigation requirement. And that simply has not been met here. One more point, Your Honor. Again, I mean, what plaintiffs should have known, right? And that's a successor liability theory. And that's supported, that plaintiffs were aware of a possible cause of action against Michigan State University years ago. And that's supported by, the complaint and the exhibits that were attached to our defendant's brief, as well as plaintiff's brief. And again, I know we argued this already multiple times, but I think it's very important to note that transfer of liabilities, that hyper specificity, that plaintiffs weren't aware that there was a document that specifically indicates that the College of Law, or the college, Michigan State University, undertook or assumed the liabilities of the College of Law. That's not damning here, Your Honor. That's simply, codifying essentially a successor liability theory, which if plaintiffs had been diligent, they would have already discovered. And whether or not they thought to or ask for that document specifically in a FOIA request is irrelevant. They could have asked for it, And as Your Honor noted, they could have made a FOIA request here, and it wouldn't have to have specifically stated, I want the document that indicates that there's a successor liability here, or that Michigan State University acquired the liabilities. And to avoid repetition, Your Honor, I'll just conclude and rely on my brief and request that this case be dismissed pursuant to MCR 2.116C7. Thank you.
Has there been an answer filed?
Pardon?
Has the state filed an answer?
No, we filed a motion in lieu of an answer, Your Honor.
So we've had no discussion.
I believe, Mr. Cousins, correct me if I'm wrong, we did, after we filed our motion, I believe Your Honor asked us to issue a scheduling order, and
Yes.
we came up with a scheduling order. Can't remember the dates. I
I understand. Okay. But basically, everybody's waiting on this motion.
yes, Your Honor.
All right. Anything else either about this matter or any questions about the status of the case or anything now that we're all together?
Anything further, I would say would be repetitious, Your Honor.
Okay, great. Well, thank you both very much. Thank you, Ms. Roberts. And all right, so this hearing is concluded. I'll endeavor to get you an opinion as quickly as I can. I confess that doing these Court of Claims cases in addition to the Court of Appeals is shockingly demanding. But we're getting them as fast as we can. So thank you.
Thank
All
you,
right.
Your Honor.
Thank you, Ms. Roberts.
Take care now. Okay, bye-bye.
Nobody needs a copy of the transcript.
Not at this time.
Not at this time. Thank you.
Thank you.